One
Record.
sec.
Just gonna hit the record button so we can go ahead and record.
Okay.
And you're away.
Okay. Welcome everybody to Woolgard Geomatics College. Woolgard Geomatics College is a non-profit collaboration of individuals donating their time, resources, expense, experience, and knowledge for the betterment of the land surveying profession. We're not affiliated with any professional association, other college, university, or business. We are an informal gathering of interested land surveyors, articling pupils, and others stakeholders in the geomatics field. Our goal is to participate in open dialogue on various topics with invited guest presenters that can lend their expertise and knowledge to the discussion. The gatherings are intended to educate and broaden the knowledge of students and surveyors alike in various areas of practice for the betterment of the profession. We're live online from September to March on Wednesdays at 4:30 p.m. Mountain Time. So our financial contributors for Woolgard Geomatics College this season is Rob Pinkerton. And if you would like to see your name up there, please donate. And you can do that by doing an e-transfer to Woolgard Geomatics College at gmail.com. And we would appreciate anybody who would like to donate. Put your name. We'll put your name up there or your company logo. And thank you for the financial contributions. You can also make a check out to Woolgard Geomatics College, care of Centerline Geomatics, Bay 140, 2730, 3rd Avenue, Northeast, Calgary, Alberta, T2A, 2L5. So don't hesitate, make your contributions to Woolgard Geomatics College. You and your friends can now subscribe to the college's electronic weekly mailouts in just 3 easy steps. Step number 1, have a friend of yours who is receiving the email, send it to you, and at the bottom of the email, you will find a place where you can add your name and address and then hit sign up, and you'll be automatically added to the email. So don't forget, send it to a friend or anybody that might be interested in geomatics and have them sign up, and they'll be on the email list, and it's all for free. So don't hesitate. So our disclaimer, all the views conveyed in this presentation are those of the presenter. The profession of land surveying has regional quirks and specifications. The material in this presentation is not intended to be specific to any particular jurisdiction, but rather to be a general discussion of concepts. So today's hot topic is, I'm just going to flip my page. Today's hot topic to Woolgard Geomatics College presents a corner recordation and dormant plans. And our presenter today is Mr. Michael Thompson, PServ, ALS, CLS, and PEng. So take it away, Michael, and I'm going to turn off my mic and camera, and you can then have the whole show to yourself, and I'll come back online after you've finished your presentation. So thank you, Michael, for volunteering, and we'll catch you at the end of the program.
Okay, thank you very much, Ross. Yeah, my name is Michael Thompson. I'm in private practice down in sunny southern Alberta in Lethbridge. And today we'll be talking about the land sales process as well as a few other items on about dormant plans and the corner recordation index. So here's the outline of what we're going to be talking about today. But I guess we can just get right into it, starting with the title. So here's a certificate of title in Alberta. We are going to be concentrating on Alberta very specifically through the presentation here, so won't be terribly applicable to other provinces. But in Alberta, we use the Torrens system, have since 1887. There's three principles of the Torrens system. We have the mirror principle, which is what's on the title reflects what's on the ground, I guess you could say. What's on the title reflects the rights in the land. You have the curtain principle, which means you don't have to go any further than the title to see the rights in land. There are exceptions that we'll talk about. And I think I should put assurance principle, but the title is assured from defects, and there is a fund held by the Alberta government to correct such defects in title. So that's kind of your three principles of the Torrens system. If there's any questions along the way, feel free to interrupt me either with your voice or in the chat box. So what do we got on here? We have the title number. Oh, you probably can't see my cursor, but on here there's a title number in the top right corner. There's a link number, also known as the land identification numeric code. Unique number in the top left corner. Short legal, which is in the top middle, will be plan block lot in this case, or that might be the quarter section. Of course, your full legal description, owners, and then here it says as joint tenants. Oh, we can, yes, you can see my cursor, okay? You have joint tenants here. I might say tenancy in common, life estate, but that's where you get the type of ownership. And then followed by all of your interests and encumbrances in order. And at the back end, the date of your title search. So we'll get a little bit more into that, but sometimes we get these legal descriptions that are quite lengthy. They're not like Maritime's Newfoundland lengthy, where it goes on for 3 pages, but it can get a little involved where you have to go step by step to kind of retrace what your boundary is. Sometimes they line up with the neighboring parcels, sometimes they don't, but in most cases, fortunately, they do. And yeah, so in this case, you'd have to, well, I won't be here saying exactly how to retrace this, but you 300 feet this way and 290.4 feet that way. That's how you get your parcel, of course. There would not be new meets and bounds descriptions like this. It would all be by lot block plan or descriptive plan, but these are historically part of the system. So when we say tenancy, we mean the type of ownership in a title. Joint tenancy would mean right of survivorship. So that would be if you have a husband and wife or any number of people that have joint tenancy. If one of them passes on, then the ownership goes into the names of those that survive. Whereas tenancy in common, if we have Mike owns 50% of a title and Brian owns 50% of the title and Mike passes on, then Mike's estate now owns 50% of a title and Brian still owns his 50%. So you don't have that right of survivorship. You can also have lease, which is not a right of ownership, but a right of lease or lease and use as if you're owner for a period of time. Or you can have life estate, which is kind of like a title on top of a title that says you own this, but when you die, the life estate comes off and it goes back to the base title. So in those cases, when you're searching in Spin for a title, you might actually see 2 titles. One's the life estate, one's the base title, and you pull both those to see registrations on either the life estate or the base title. As for the encumbrances, there's quite a number of them. This is not a exhaustive list, but you have a caveat would be, well, I will talk about caveats, so I won't say too much about that here. But as you can see, quite a number of types of agreements. List pendants just means pending litigation. You have future expropriations, the fact that's in irrigation, the parcel's in an irrigation district, encroachment agreements. Of course, on the some other things on the left-hand side here, which I'll get into. So caveat, it's buyer beware or let them beware. It can be for a lot of different types of interests. Like you could have a caveat regarding a utility right-of-way that's on title, just saying warning there is a utility right-of-way, which is not the same as a utility right-of-way. It could be for road agreements, agreement of sale. It could be for bankruptcy proceedings that are happening against the parcel, even adverse possession, surface rights orders, first right of refusal on the purchase of a parcel. Quite a long list. I would say if you go to the Land Test Procedural Manual, you can actually look up the CAVE-1 document. It'll say, here's all the things that are acceptable, and here's the things that are unacceptable as registered caveats. So basically, if you have a caveat, if I register a caveat against Brian's title, no one's really going to check that I have that actual agreement. I just say I have interest, and here it is. And then if I'm called on, it'll be up to me to back that up. Encumbrance is the term we use for anything that takes away the rights of land or assigns rights in land to another person. So an easement or right of way would be an example of an encumbrance. Terminology of easements and right of ways I find is often misused. Part of that is that in different provinces and jurisdictions, the terms don't mean the same thing that they would in Alberta. So first of all, just say in Alberta, an easement is the right of one parcel over another parcel. So parcel A has a right of access over parcel B, as opposed to a right of way, which would be a legal person has a right over a parcel. So ATCO Gas has a utility right of way over parcel B. But if you work in BC, a right of way would be what we call easements in Alberta, and what we would call a right of way, they'd call statutory right of way, and then changes in various jurisdictions. But in Alberta, that's the terminology that we use for easements and right of ways. And then we also use the terms dominant and servient tenement, which is fancy wording for the dominant tenement is the person or parcel that holds the right. And the servient tenement is the person or parcel that's subject to that right. So if I have an easement, or if I'm parcel A and I have an easement for parcel B, I am the dominant tenement. I have the easement over that parcel. That's the servient tenement. We have something called a blanket easement or right-of-way in Alberta, and all that means is that it applies to an entire parcel. So if there's a utility right-of-way or an access right-of-way, and there's no plan of survey and there's no meets and bounds description attached to it, then it just applies to the whole parcel. So in terms of whether you need approvals on subdivisions or that type of thing, it's not limited to a certain area other than what is stated. So either a plan of survey or a meets and bounds description, say the northerly 10 meters of parcel A. On the title, when you're looking at the list of encumbrances, you'll know if there's a meets and bounds description to follow. Hopefully there is to follow. If it says portion as described, so that's how we know, okay, this is limited to a specific corridor or placement on the parcel. If you see a lien, that's a fiscal claim against land for work performed. I'd say if you're doing new work for a client and there's a bunch of liens on their property, you should probably get a signed contract and maybe a retainer before you go forward on that. List pendants just means pending litigation. You'll often see this on a title if there's, say, a divorce happening between a couple. And then we have restrictive covenants, which is contractual agreements binding on the land use of one parcel for the benefit of another parcel. That's mostly true. There are types of restricted covenants that can be put on by municipality, Section 652, I believe, of the Municipal Government Act. But if it's going to, for the general application of a restricted covenant, It's only enforceable by a parcel when there's a direct negative effect on the dominant parcel. That's won't get too far into that, but the important thing to know is that not all restricted covenants that are on title are enforceable. There's some legal principles behind that that say unless there's actually a direct negative effect by the dominant tenement, then if not, it's not enforceable. So we often see these. One place we'll have to know about encumbrances is if we prepare real property reports, because our real property reports are going to note any encumbrance that affects the extent of title. So say, for example, we're going to say utility right-of-way for the city of Calgary. That's an interest in land for the purpose of utilities. That affects the extent of title. If someone has a mortgage on their property for TD Bank, that's a fiscal encumbrance on title. It doesn't affect the extent of the title itself. We don't list that in the real property report. It's important to talk about the priority of registration. So a title is like a list of everything that goes on. The first thing is at the top of the list, second things that comes along is on the second item of the list, the last thing to get registered is on the bottom of the list. So why that's important is that the order of registration is the same order of enforcement of interests. So if you have two mortgages on title and someone's going into bankruptcy proceedings, the first mortgage to get registered is going to have the first interest on that, pending if there's bankruptcy proceedings. That may be a bad example because that's going to be figured out by the courts. But the important thing to know is that the priority does matter. So what's registered first has first priority over competing interests that are further down in the title. So here's the three sections of the Land Titles Act. I won't get too much, but it's here for your reference later. This is, you have 56 that says there is priority over one over the other according to the section 14, not date of execution. What's section 14 say? Serial number assigned to the instrument or caveat shall determine the priority of instrument filed or registered. And 147 allows for discharge caveats to replace in original priority. So the reason I put this in here is these are the three sections that would allow for a common thing to happen, which would be if there's a caveat regarding, say, a utility right-of-way, and that gets replaced by utility right-of-way. These are the three sections of the Land Titles Act that would allow it to keep the same priority, even though it got registered later on. Hopefully I said that proper. Tony will let me know maybe later.
No, you're doing all right.
Okay.
The 147 replacement is almost exclusively for utility right-of-ways. And that's where the right-of-way is a signed agreement that takes the place. The caveat is simply a placeholder in that case.
Yeah. And I just put that in because that's something that may or may not come up when you have examinations for articling pupils, is that you have a caveat regarding utility right-of-way. Sometimes they'll have to get replaced because you're going to attach a plan of survey and it was originally registered as a caveat because the land agent was lazy or whatever the case is. And when you have the replacement registration, it holds the priority is the same priority as the original caveat. So the new utility right-of-way goes on there, not as a caveat, but it keeps the same priority. That's the paraphrase of what that last slide was. But moving on, how do you register a plan? Okay, so when we register a plan, I'll have some slides on this, but first of all, you need to submit a drawing file to the Survey Plan Online Checker of your plan. That's SPOC. That will check that all the land sales layers are in the right spot, and if they're not, it'll spew back at you that you have problems with these layers and you should go fix them. So then out of SPOC, you get a zip file. That zip file contains a drawing file, a TIFF file, or a plot file, I guess historically, and a XML file, which is like encrypted file. So those are the three files that are within a zip file that the surveyor will upload to the Common Web Interface, which is the FTP site that surveyors use to upload their digital files to land titles. Then we're going to create a document registration request, which is below as well. And as a minimum, provide a surveyor's affidavit. So every plan survey you register at land titles will have the affidavit of a surveyor saying, you know, the survey was completed by me on these dates in accordance with the Surveys Act, Land Titles Act. Now I'm thinking about it, my example might be out of date now because I just changed. But we'll talk about Spock first. Survey plan online checker, it'll look like this. You can see you can upload your TIFF file, survey date. It asks you where it is. Is this a delayed posting plan under Section 47 of the Surveys Act? How do you survey it? Was it geo-referenced? What's the datum? This would be when you say it's projection, 3TM, UTM, central meridian, 114, 117, whatever the case might be. So basically, you have all that information on the properly completed plan of survey. The step to upload to common web interface, it looks like this. So you would have login for the surveyor, attach that surveyor's account. So this one, it says FTP SP 793. It's called that because my commission number is 793. And you just upload the files that were spit out of Spock, and you upload the zip file. That gets pulled by the land titles examiner for review. For articling students, I would say it would be important to know the 3 types of files. I know I already said that, but maybe ingrain that in your brain and write that down. It might come up at opportune times. So DRR, document registration request, we log into Spin, and there's this little tab here, DRR. That's how we get to it. So it's required for every land titles transaction through the website, and there's no option to do a non-electronic registration. It's got to. This is the only way to get anything registered at land titles now. And this is the screen that comes up when you're filling out your DRR. So you have your typical account information, whether you want to return something by mail or a call box. Sorry, no fax confirmation. This is out of date. You used to be able to get a fax confirmation. They don't do that anymore. Now you just got to wait for the plan of survey to be sent to you by email, and that's generally how you know that your registration is complete, short of checking Spin all the time. I'm not bitter about that at all. Of course I am. And then specific instructions. So something I might say is my files are on FTP site 793, so I may say that right in this special instructions file. And then you just drop down your documents, whether it's land transfers or utility right-of-ways or plans of survey from monument plan, right-of-way plan, subdivision plan. Fill in the types of land with your short legal, plan block lot or quarter section description, and add them all in. So order matters. So this is like when you have item 1, item 2, item 3. You're going to want to make sure they're in the right order. For example, if you were to register a subdivision with a utility right-of-way, you need to register the plan of subdivision, the utility right-of-way plan, and then the right-of-way agreement for the utility right-of-way. You can't put the right-of-way agreement ahead because that will say plan number such and such or plan number blank. And we need plan number blank to exist as a plan before we can register a document that refers to that plan. So it's just important to put it in chronological order, make sure you have the right registration order for your particular set of documents. Another example would be you need to if you have a transfer of land for a new parcel you're subdividing, that needs to come after the subdivision because the parcel needs to exist before you can transfer it. The best source for information on registrations and how to get things registered, the LTO procedural manual. I have the link right here. It has a large breakdown. SUR would be things to do with surveys. SUB is subdivisions. I mentioned before CAV is caveats, but go to this link and you can get all kinds of information with footnotes on the right part of it. 1980. Brian Ball said 1980 called and wants their fax machine back. I tell that to my legal clients that still fax me requests. I mean, it comes through on a BizHub. I don't have the fax machine, but still. Okay, so what happens if you don't get everything right? Well, you're going to get a DRR rejection notice. So nowadays you'll have 30 days to respond to this, otherwise they're going to, or you'll lose your priority in file. But basically you're going to get this DRR notice of deficiency. It will states further down what the, I don't have anything there, but say for example, if you had shown, what would be a good example? I guess you had incorrect survey dates, or the survey dates didn't match what the surveyor's affidavit said. It will say, here's what the issues are. Either email us back with a plan that meets those requirements, or if the documents need to be returned, then they will be returned. So say for example, someone used whiteout on a document, and that's not allowed by land sales. It would say, you used whiteout, we're sending this back to you, give us a new document that doesn't use whiteout. It's important to note now that if you do need a bit more time, like say me in Lethbridge, I have to get the documents, I have to get it fixed, I have to send it back. You can send a letter to land titles on company letterhead that says, can you give me a 1 week or 2 week extension, something like that, so that I can get these documents together, and then they'll extend that 30 days. But as it sits right now, if you get a DRR rejection, 30 days passes, land titles doesn't hear back from you, it'll fall off the queue. And then in order to get that registered, you'll have to fill out a new DRR and go back through the process, which is important right now because surveys are taking something like 3 or 4 months to get registered. Okay, so I'm just gonna, unless there's any questions coming up, I'm gonna go through a few types of common registrations, common plans that surveyors register. We'll start with something simple, being the monument plan. So besides your plan survey, if you have a monument plan that shows where monuments are placed, you're only going to need 2 things. One is the spot submission, which is the plan of survey. You have your surveyor's affidavit, the document says the survey is completed by me, surveyor, these dates, Land Sales Act, Surveys Act, and your document registration request. And that'll actually be, you complete it online, but you print out the DRR and send that in with your affidavit. So that's as simple as it gets. Slightly more complicated, but still not very complicated, if you have to register a right-of-way plan. So same as a monument plan where you have the spot submission, you have a surveyor's affidavit, you have the document registration request. The one additional thing is we have a consent of a person requesting a survey, and that person could be a corporation, a municipality, an individual. All that Land Sales really cares about is that the person that requested the survey actually is signing off on it, with an exception we'll get into with Dormant Plans. So in this case, we have plans showing survey of utility rights of way, City of Lethbridge, it might say requested by City of Lethbridge. We'll have a document that says, sorry, I was just being interrupted by something, my apologies. So in this case, we have the City of Lethbridge signing a document saying we are the corporation that requested, or the person that requested this survey to be completed under Section 81(2) of the Land Sales Act. So far, so good. So for that consent to a plan, like I just mentioned, that City of Lethbridge on that utility right-of-way example would have signed off a document saying, yes, we requested the plan. So here's the PDF form for consent to a plan. So that might be from the registered owner in the case of a subdivision or consolidation of properties, anything to do with the title of the property being affected, the registered owner would be signing off on that. You might have someone that holds an interest in the case of, say, a subdivision that has municipal dedication of land or public dedication of land. So then you say you have an interest. If it's a subdivision, any subdivision where it's an irrigation district, that you need that consent as well. But basically, we, either the owner or having registered interest or being the person who requested the survey to be done for right of way, Hereby consent to the plan prepared by Michael Thompson, ALS, file number in respect of legal description of lands. So that would be your general format. So if an individual signs this, it's going to be, you're going to have an affidavit of attestation, which I think I have in my next slide, which basically this gets signed before a witness. So here's the owner, or what the case might be. Here's a witness. Page 2. I, witness of the city of Lethbridge in the province of Alberta. I was personally present and did see Bruce Goodham, who I know because I've known him for a long time, or I was present, I did see Bruce, who I didn't really know, but I ID'd him, and I believe he is the person that signed the instrument, or is the person who's named in the instrument. The instrument was signed at a city in the province of Alberta, and 18 years old, and that gets signed before a commissioner of oaths. So it's kind of a backward system, but you have page 1, signed by person who matters, in front of witness. Page 2, witness, signed before a commissioner of oaths. It's beyond me why you wouldn't just have page 1 before a commissioner of oaths, but that's not the way our legislation works. So this is how we got to do it. If you have a corporation, you have a couple of options. You either have the signature of the corporation and they have municipal or a corporate seal, and they go crimp, and then you're done. You only need page 1. But if you don't have a seal, you need the attestation of an instrument here. But you also need something called the affidavit verifying corporate signing authority. So the person who signed on behalf of the corporation says, I am an officer of the corporation and I can sign without a seal. And I can sign before a commissioner of oaths. I have a comment that from Tony Bennett, who has way more experience with this than I do. It should be pointed out that the majority of rejections are poor affidavits. Yes, that is true. So say, for example, you might have someone saying, I'm the registered owner, and then it's signed before a witness, and then maybe the witness doesn't fill this in, the registered owner fills in this document again, and that's just not going to be allowed. You're going to get a DRR rejection saying, give us a new document or correct the document, and that is then get it back to us in 30 days. So it's very important to review these documents, make sure that everything is in good order before you send it off to land titles. It will save you those headaches of trying to fix the documents later, especially seeing as anything wrong with the affidavit generally will have to be sent back and the paper copy will have to be amended because it's those wet ink copies that need to be used. It should also be noted that municipal corporations, so if you're working for an incorporated town, village, rural municipality, they got to use a municipal corp seal. So they don't have the option to use these forms. Okay, moving on to registrations for a subdivision plan. Oh, and actually, one thing I forgot to put in here, sorry to back up, is there's a section of the Land Sales Procedural Manual that now deals with, where's my stamp here? Anyway, it's a very similar stamp. So again, they have a affidavit that says, or correction to minor documents is what's in the Land Sale Procedure Manual. So surveyors can have a stamp that says, I'm making this correction on behalf of this person, and we can stamp that and sign off on it, which is generally allowed. You'll have to read through that section of the Land Sales Procedural Manual, but as a general rule of thumb, as long as it's not being signed off by a commissioner of oaths, then you as a or changing anything that's key, then you as a surveyor can make a minor correction. So something like a typo in a legal description or in a person's name or the name of a corporation, if that gets rejected and sent back to you as a surveyor, you can stamp that, sign it. You have to have permission of the person that signed it in order to do something, which you could back up with an email saying, hey, I'm just correcting this on your behalf. Send that back to land titles. That way you don't need to bother getting people to come in to correct it themselves. If Commissioner of Oaths has signed off on something, then the rule of thumb would be that Commissioner of Oaths will have to initial off on that correction. So that makes our life a little bit easier. I do like that. Talking about we're on subdivisions though. So we went through monument plan, right-of-way plan, what's required. So you need a little bit more with the subdivision. So you send your subdivision into land titles. You have your affidavit. You submitted your plan package to the Common Web Interface, FTP site. You're also going to need the consent of the owner, which makes sense. You can't subdivide land without the registered owner and title consenting to it. You're going to need the endorsement of the subdivision authority, with few exceptions. Which I think that's for another presentation. We're not going to talk about subdivisions in depth, but with exceptions, some exceptions, you'll need the endorsement of a subdivision authority. If there is a public land dedication, so that'd be like a public utility lot, municipal reserve, a road included on the subdivision plan, then you're going to need the consents of almost the whole list with a few exceptions. Like the exceptions include mortgage of utility right of way, things listed in the Land Titles Act. If there's, say, a utility right of way that refers to a specific plan of survey, and that plan of survey is outside of your bold line on your subdivision plan, then you don't need to have consent for that. If it's a blanket, affects the whole parcel, you'll need the consent for that. If there's land that's accreted into the parcel, you'll need the water boundaries unit to also consent to that plan of survey. If you want to know more about that, I presume you can go to Dr. Ballantyne's presentation from last week, and he'll probably tell you a little bit more about that. Much bigger topic than what we're going to be covering today. If you have a delayed posting plan, I should mention, it used to be a 1-year time frame that you would have to register a monumentation certificate, but now it's been extended to 3 years. So if you have a Section 47 plan, the thing that would come later is once you put the posts in, then you would file a monumentation certificate. Okay, so what else do we have that we might be setting to land titles? Well, we might be setting a road plan into land titles, something that doesn't deal with parcels except for a road. So what do we need? Well, the surveyor's affidavit, and of course, the upload to land titles for the plan. We'll have something called a certificate of designated officer for a road plan, which I don't think I have in here, but it's actually recently changed. So all you surveyors watching, make sure you're going to be using the new format for certificate of designated officer for road plan. It basically says, hey, we're registering a road. We are the municipality. Agreements have been reached with all landowners, or any interests within 40 meters have been notified by registered mail. So if you have, like, say, a well site that's within 40 meters or interest within 40 meters, then they've been notified according to Section 62 of the Municipal Government Act. And then that's countersigned by a commissioner of oaths. That's commissioned, not sealed, because it's actually the designated officer of the municipality that's signing it, not the municipal corporation itself. There's an exception to that, is if roads being taken off of a parcel that is already owned by the municipality, then you could have there's not a form on Land Title's website, but you could have a letter from the municipality saying, hey, we already own this land. We're not going to notify everybody with the 40 meters, but according to this section, which of course I'm not going to know off the top of my head, this section of the Land Titles Act, we are going to register a road plan, but we're not notifying anybody because we already own it, and that's okay. And then next one we have is Public Works Plan. So I guess first of all, what's the difference between a road plan and public works plan? Well, public works plan would be something under a provincial ministry. So a highway would be a public works plan. Other examples I've seen is like seniors and housing. But basically it'll be something that's going to get titled to the provincial government, or it's a highway, which wouldn't have a title but still be under their jurisdiction. So in those cases, you would have a surveyor's affidavit. You'd have a certificate of authority for a public works plan, which also would say agreements have been met with the landowners. So you don't have like a transfer of land that gets registered with it. You just have, like, say if it's a highway, Alberta Transportation says we've made agreements with all the landowners, we've acquired it either prior or by other agreement, and now we're going to take that land formally, so that'll be accepted from the titles. So in this example, if you have titles on either side, this bold area is getting taken out. Now we'll have certificate of title 821, etc., saying it's this quarter section, accepting they're out. Public Works Plan 1, 2, 3, 4, 5, 6, 7. Then one
Michael,
other.
can I
Yes.
just jump in there? One
Yep.
of the problems with public works or road plans is the schedule of areas. And it is vital that your schedule of areas be broken down to individual titles affected. You can't just say we're taking 2 acres from the northeast quarter. If there's 4 parcels out of it, we need to know precisely which one. Tremendous amount of trouble if that isn't broken down that way.
Absolutely, that's a great point. So you'll see on this side, we have area required for road, and it's within the northeast quarter of section 34, but we have within this certificate of title is this area, within this certificate of title is this area, and then total is whatever it is. So either you're going to have that per quarter section if it's kind of a long linear plan, or if it's more of an urban style plan where it's out of a lot of smaller parcels, then you want to have a schedule of areas in a tabular form off to the side that lists every parcel. Now that's a great point, Tony. So other plans were, this isn't a presentation on exactly what to do with a condominium or a railway, but just to let you know that there are particulars for these other types of plans. Condominiums would be anything that's broken down into units as per the Condominium Property Act, either bare land or building units. Railways are very similar to roads, canals as well. Strata plan would be an airspace plan. So example would be maybe you have a apartment block that's above a parkade, and the parkade's for a mall that's next door. So you might have to have airspace for the parking area versus the building above. Perhaps you have subdivided out by strata for support pillars that are holding up that unit, but there's not very many of those registered. It's for cases where you need to divide title just based upon airspace. You have settlement plans, and that would be if you're bringing ungranted land or on land that's in the public land system into the land title system, you would have a settlement plan. So that would be a Part 2 survey of the Surveys Act, and then so you treat that very much like a township plan. It's the originating plan. If there was further subdivision of a settlement, then that's Part 3 subdivision, just like any other subdivision in settled lands. And you can also just have reference plans. Examples would be for expropriation, power substations, road closures. You might have area A of a road closure so that a municipal bylaw says we're taking area A plan blank. You send that all in to it. But, the point is there's a lot of different registrations, and I'm not going to get into all of them in this particular presentation, but go to that Land Sales Procedure Act manual. It's a great place for reference. So then we're going to talk about discharging instruments. So discharge, that means that we're going to be taking the interest off of the title because we don't need it anymore for whatever reason. So one common thing that surveyors will do, especially oil and gas industry, is right-of-ways being partially discharged as to a plan of survey. We were talking about this with those 3 sections of the Land Sales Act before. You'd have a discharge document saying we no longer have an interest in this caveat from XYZ utility company. And then right after that, next in document registration order, you'd have utility right-of-way document referring to a plan of survey. The reason you have a utility right-of-way document is because a caveat can't refer to part of a parcel. You can't have a right-of-way plan and then the caveats within the right-of-way plan. It's the utility right-of-way document, not a caveat, is required to limit the spatial extent of an interest to that right-of-way plan. Good for surveyors, gets us a lot of work. So that would mean that if you have a caveat document and say it has an individual ownership plan attached to it saying this is the area that the landowners agreed to, as far as land sales is concerned, that's a blanket agreement. The caveat applies to the whole parcel. It doesn't matter if there's some engineers or even surveyors individual ownership plan attached to that. If there's anything in the agreement that's attached to the caveat that says this is what it's limited to, the land sales office is going to be blind to that. It's a caveat. It applies to the whole thing. If there's some court proceedings or damages based upon the use of that utility right of way, that's a whole nother story. That's for the courts to figure out. But in terms of if you need to determine whether you need approval for subdivision from a particular utility right of way, maybe it's outside of the area shown on an individual ownership plan, then land sales doesn't care. You still need that consent from that caveat because it's a blanket. I should turn to this slide because that's exactly what I just said. So caveats cannot be a caveat regarding right of way. How do we partially discharge a caveat? So that's what we do. We take off the whole caveat. We register new right of way agreements on the same DRR, referencing Section 147 of the Land Sales Act. And then if in cases, you might also have a case where it's a utility right of way that's a blanket utility right of way. Like it's not a caveat, it's a utility right of way, but it's a utility right of way as to the whole parcel. Maybe later we come do the plan of survey. Now we want to not be a blanket, we want to apply to the plan of survey only. In that case, you can do a partial discharge of utility right of way. So you don't need to go through this whole process. You just partially discharge. That goes on the title, but the original utility right of way, where it was registered, and its number, registration number are still the same. Oh, so what if you have an old caveat and maybe it's a corporation that doesn't exist anymore? Yeah, we have a few of those in Alberta, especially in the oil and gas industry, and you need the consent of that legal entity, and there's no one to consent because they're not around. Well, you can do a lapse of a caveat. So you have to serve notice, and that would be the either process server or registered mail to the registered address of the corporation, or if it's a person to an individual person saying we're going to lapse this caveat unless you give us proof or that you back up the claims that are held in that caveat. And then you wait 60 days. And you can have judges' orders that limit that to less in extreme cases, but basically how it usually works is corporation doesn't exist. There's a corporate address. You serve notice, you have your registered mail, you have the proof that you served registered mail, and then you can fill in this lapse of caveat document. So you pull that off the title, and then you don't need their consent anymore, and then you get your subdivision registered or whatever the case might be. Another type of registration we have is a removal of reserve designation. So for subdivisions, we typically have 4 different kinds of reserves. We have a municipal reserve, which is like a park. School reserve, same thing, but for a school. Oh, there's more than 4 actually I'm going to list off because there's municipal and school reserve, which would be MSR. You would have environmental reserve, ER. And there's also public utility lots, which are a little different, but they are for utility purposes. So if you're going to get rid of, or if you have a municipal reserve lot, you want to dispose of it, otherwise deal with it, and it can't be a municipal reserve anymore, then you need to go through a process of removing that designation, which has public hearings, which is usually a poster board in the foyer of City Hall, or it might just be office hours in smaller municipalities. You need to advertise in a local newspaper. And then once you've gone through that process, you can actually remove the municipal reserve designation. Public utility lots are a little bit different in that it can be by a letter from the municipality to remove the PUL designation. And environmental reserves they're basically stuck. It would take it's a more involved process for an environmental reserve. We had mentioned road closures a little bit earlier. So road closure is a bylaw. In the case of a city, that they can just register a bylaw without going to the province. But in the case of anybody else, a town or a rural municipality, anything lower, it also is signed off by Alberta Transportation or the Ministry of Transportation. So you might have cases where you're closing, say, a road allowance, and it's a full half mile of road allowance adjacent to quarter section. In that case, it would be sufficient in the road closure bylaw for the municipality to say road allowance adjacent to such and such quarter section closed, and then titles created for that. But if things are a little more complicated, you're going to need a plan of survey, and that's where you would have a reference plan for that road closure. That way, the municipal bylaw that gets signed off on can say we are closing road area A of plan such and such by Michael Thompson. And then when we send that to Land House registration, we would send in the bylaw, typically a certified true copy of the bylaw document, along with the plan of survey. The typical way a town would close a road would be to have advertising and public hearings, much like municipal reserve designation removal. Through first and second reading of the bylaw, goes to transportation, sits on their desk for 6 months, someone finally signs it, goes back to the municipality, third reading, they sign it, and then it's passed by law, and that bylaw can be registered along with the reference plan at land titles. And what you get back is a title for that property in the name of the municipality, or in cases where it's being transferred within the bylaw, it could also come back in the name of the adjacent landowner and consolidated with that property. In terms of highways or provincial jurisdiction property, that could be closed by notification, just a different type of document that would be provided to you by the Ministry of Transportation or who you're working for, that would result in a title being in the Crown and the right of Alberta as per Ministry of Transportation or whatever the case might be. I'm saying a lot. Are there any questions? Am I moving too fast?
Michael, a couple of things. Your slide showed an MSR, and the procedure for closing that is that the Minister of Education must approve the selling of a school reserve, and they provide a letter which dictates how the monies will be divided up. That school reserve portion can then be closed and sold only to the municipality. So when a school reserve is canceled, the land must be sold to the municipality and then consolidated with any other municipal parcels or become a reserve on its own right. So there's a second step there that's quite important.
Okay. Yeah, it's a good point. Thank you for that, Tony. So yeah, I guess that's the particular section as an example. Okay. Now, where was I? So what are some other common registrations that we'll deal with? Obviously, us surveyors, we think, oh, either we deal with subdivisions or we deal with right-of-ways. But when push comes to shove, we actually register a whole bunch of stuff that allows our clients to get things done, to get stuff moved over. Like a lot of parcels are being sold because grandma died, and now we got to have an affidavit of surviving joint tenant, for example. So if you have two joint tenants, Mr. and Mrs. Smith, Mr. Smith dies, well, there's a document for that where you can have, you attach the death certificate or a copy thereof from a funeral director and say this Mr. Smith has died. The title says Mr. and Mrs. Smith. Please change it so it reflects that Mrs. Smith is the only owner, because we can't have Mr. Smith sign off to consent to the subdivision when he's not around anymore. You might have to have a change of name if someone gets married, or in cases where maybe the name is incorrect, although that would be more of a statutory declaration. You might have to change address. So if someone has the incorrect address on title or they've moved, there's a change of address document. I'm Mr. Smith. I own this parcel. My new address is this, which I believe is still free as long as you're doing one property. They charge extra for additional properties. You might register a lien. Maybe someone didn't pay you and you're within that time frame that allows you to register a mechanic's lien. Well, I've never actually done that, but in theory, if someone owes you money and it's in for work on that property and a mechanic's lien is allowed for that, or a different type of lien, a builder's lien, then you can send in that. That has a bit of a different registration priority because it's very time sensitive. You also have power of attorney. So if someone's incapacitated, maybe they're not able to handle their own affairs, then you have the power of attorney where next of kin or whoever stated in the power of attorney needs to be able to sign on their behalf. So if Mr. Smith is getting on in years and Mr. Smith's daughter has power of attorney, in order for Mrs. Smith's daughter to sign on behalf of Mr. Smith, you need the power of attorney documents to be registered at Land Titles, and that would be a DRR item. Typically, that gets registered once, and then it's on file at Land Titles for future transactions. And of course, the transfer of land, which with the type of work I do, I get a lot of these. Actually, most of my DRR rejections have something to do with the transfer of land. A lot of irrigation work I do for it will involve foreign ownership documents and whatnot. So typical transfer of land, you're going to have the document that says, I, owner, transfer land such and such to new owner. And there are intricacies. You have to say the type of tenancy that there is, whether it's, because if you don't say it's joint tenancy up to two owners, they're going to presume at land sales as tenancy in common because that's the default. You're going to have your attestation and corporate signing authority documents right. Like Tony said, that's the most common error in documents, the most common reason for rejection. So make sure that those are witnessed and commissioned in the right spot. Do not assume that a commissioner of oaths knows what they're doing and where to sign. You review that before you send it in. You have a document called affidavit regarding value of land. So even if something's transferred for free, you'll have to say, I'm the person receiving this land. I know that I paid X number of dollars. Maybe it's $1 if it's nominal. Maybe it's more. Then in my opinion, this land is worth $1 million, whatever amount. And just so that it shows, like, I know that this, even though I'm getting gifted this land, or I know that even though I paid this much, I believe it's this much. I mean, if you bought the property and you bought it for $100,000, you believe it's $100,000, it would just say, I paid $100,000 and I believe it's worth $100,000. There's also dower affidavit, dower courtesy, where that would be if you have a parcel of land and it's in one owner, if it's in the name of Mr. Smith, then Mrs. Smith, if Mrs. Smith exists, would have dower rights over that property if it's their homestead. So if it's the place that they were married, they've lived in as a married couple for long enough to be considered common law, or if they were formerly married, then they would have a right in that. So you're going to have a situation where someone's not married, and then the dower affidavit would say, I, Mr. Smith, am not married. Or maybe I, Mr. Smith, am married, but this property isn't our homestead, so it doesn't matter. Or then it gets into more complicated matters, like, or we got divorced, or there's court proceedings. In those cases, you'll likely have to have a lawyer actually completing the dower affidavit as opposed to just something in your office being signed off by a commissioner of oaths. And then the bane of my existence for DRR rejections, foreign ownership of land. So if you have a controlled area, and a controlled area would be basically anything outside of an incorporated municipality that is being transferred, then there's a document that needs to be signed off on. The typical situation would be either you have a Canadian corporation or a Canadian individual that is receiving the land, and they would say, I, Canadian person or corporation, am receiving the land, and I'm holding it for myself. I'm not holding it on behalf of any foreign entity or corporation. And then if you have a corporation that has shareholders, well, for any corporation, you have to break down the shareholders and the types of shares. And if one of those shareholders is a holdco, then you need to have further documents where it's further broken down amongst shareholders. if you get into situations where a church owns property or a not-for-profit owns property, then there's additional documents that would show the directors of the church or property. Churches are a pain because you actually have to look up the specific denomination. You might have to look up the specific legislation for, I don't know, the Lutheran Church of Canada and follow those documents. But just be aware, if it's a church or not-for-profit, there's additional, you can't treat them like a regular corporation. So that's your list of things you have for transfer land. The transfer itself, sorry, yep.
Well, Mike, I was just going to say that the dower affidavit and the foreign ownership of land are the two major errors that we deal with in land titles. Fortunately, I no longer have to care about that, but those are where people just get it wrong. It's one person on title must provide a dower affidavit. There are many affidavits depending on circumstances, but the key is it's one person on title. Foreign ownership of land, you're absolutely right. The corporations can get very, very involved. And there are, my memory's failing here, 100 and some private religious foundations or entities that all have different signing authorities. And you need to be careful with those. But those are the two that really, when you're undertaking any of these things, take a second or third look at those before sending anything in.
Yeah, going back to memories of trying to call an archdiocese of the Catholic Church to say, no, you screwed up the documents, you need to do this again and follow this particular order. Yeah, bane of my existence on those transfer documents. But yeah, absolutely. So to reiterate, dower affidavit, one person on title, you're going to need it. Foreign ownership of land is also a separate department of land titles, so it takes a few more days to process. So once it goes through surveys or even through the regular stream of land titles, then it goes to foreign ownership. And if you get a rejection for foreign ownership, you actually get a separate DRR document. So you might have the first DRR rejection that says foreign ownership of land rejected this. Look at what they said, and then you have to follow what they said. Whole separate department. Moving on to plan corrections. Before I forget to say this, Tony had pointed out before the presentation that one thing to remember about plan corrections is that they can be expensive and painful to deal with. Sometimes you have something that's very minor. Example would be, say, a dimension on a right-of-way plan. Well, there's no actual ownership of land. I mean, some dimensions on right-of-way plans perhaps need a bit more, but you might be able to correct that under Section 92 of the Land Titles Act, and that's where it will not adversely affect any person, or if the person's adversely affected, consent to the corrections. So, say if you have what's a good example? A dimension, a distance on a subdivision plan. Well, now that's the right in land. So you're going to have owners on either side of that property, potentially. And those owners will need to consent to that correction as well. So if it's a right-of-way plan, not so much, but if it actually is for a registered parcel, you're going to need their consent as well. And in most cases, I would say you are probably looking at Section 91 for those types of corrections. But what you would send in to Land Titles is a letter. I think I have an example below saying what the correction is, with a sketch of what the correction is, a statement saying no improvements have been made based upon that, like no one's built a fence or otherwise improved the property based upon the error. No encroachments will be created, and no other plans will be adversely affected. So someone came along later and had a subsequent survey plan that's affected by your correction. Well, it's a trickle-down effect, and now you have other plans that also need to be corrected. Has to say, well, yeah, once again, no other plans are affected. No monuments have been moved or removed. In cases where a monument has been moved or removed, you would need permission from the Director of Surveys under, I believe, Section 50, subsection 3 of the Surveys Act, giving you permission to remove that. And if you're going to go through that process, basically you can contact the Director of Surveys office through email saying, hey, this is what I want to do. This is what I propose. Can you take a look at that? And they're going to do a deep dive into prior plans and whatnot. Perhaps it's a double posting and or a posting placed in error, and then you'll have to deal with Director of Surveys office on what you need to satisfy before they give you permission to remove that post. And lastly, no boundaries are being altered or moved, and if they are altered or moved, well, you're looking at something more complicated, which we'll get into here. So here's an example of a Section 92 correction. It's where a minor error exists. A distance of 10.90 is shown in detail. It should be 10.00 because Mike was a little hasty with his 0 and it looked like a 9, and that was never caught. And here's all these statements. And here's my contact information. So this is what the plan correction will look like. It will sometimes look like someone took a crayon to it to make that correction. But hey, if you don't want your corrections blatantly registered at land titles like this, well, get it right the first time, I guess. So it'll look something like this. In rare cases, you might have a registrar or deputy registrar make an error, like, oops, I put the wrong plan number on here. Then it'll just look like this. Perhaps not nearly as blatant, not with a crayon, but you know, that happens as well. So yeah, like we said, if it will adversely affect a party, that party must consent to the correction, and that only applies to clerical errors or minor omissions. You're welcome, Tony. Okay, so then that's what Section 92 of the Act says, is that if it's clerical error, minor, you don't need to have a court order. You can just do it in this process. Section 91 deals with everything that's worse. So if you need to make changes to a boundary or have any additions or deletions of a boundary, you're going to require a judge's order. You're going to be paying a lawyer for that, and it's going to suck. But I should point out, not every judge's order is because of a plan error. If you deal with condominium surveys, there's a lot of things that require a judge's order. They're just changing condominium plan, and that's just part of day-to-day process. If you have the consent of all parties involved, it's an expensive process. If you don't have consent of the parties, then it's a very expensive process. Because if you have consents, you can the lawyer can take in to judges' chambers on whatever day they meet in judges' chambers and say, here's the correction, here's the surveyor's affidavit saying what needs to be corrected. You might have documents from the Director of Surveys saying you can move a monument, and here's the signatures of all of the affected parties, and they're all okay with it. Well, that'll be dealt with that day in judges' chambers. If you don't have consent, then you got to go to actual court time for people that don't have consent to plead their case. So anytime you get to anything in the litigation process, I don't know if that's the right word, but the court process, yeah, it's going to get ugly. Court time is not cheap. So here is a Section 91 affidavit where a owner is consenting to a plan correction. In this case, there was an incorrect error, or area, sorry. So this is a case where the parcel is affected because we had a note from Tony, work with LTO before going to court. Yeah, you'll want to call Director of Surveys office, call LTO. If there's an error, it's best to be above board with everybody that's going to have to look at it. In cases where you have these documents, you can even send them into land titles. Someone like Dwayne McNeil at the South Alberta office will be able to take a look at this and saying, okay, this looks fine for the format. There's nothing worse than having the format of this wrong. You've already got the court order, then you got to take it back to court to get the court to amend the document, and you're spending more money, taking more time and dragging out the process. Nobody wants that. So this is what the landowner signs, like, okay, my area was wrong. We need to change it. Here's what I sign. I'm picking on myself for these. Unfortunately, I've had plan corrections, so, but learned my lessons. I signed this plan. Exchange was made between a municipality and this numbered company, and so on and so on, all the facts of the case and the fact the area needs to be put on there properly. And then here is what we get back for in the court order. The lawyer will obtain an ex parte order if consents are obtained for the submissions to the court. Cases presented to the judge or master in chambers, they would say. So you have what would be called the judge's chambers. That's where they would get that ex parte order. You get this order that comes back that says you can change this area and all the step-by-step instructions on how the plan can be changed. So there was a, don't want to go too much into my plan error, but basically this was a descriptive plan where I missed a little part of it that was way off in another part of the quarter section. So I had to change the areas. This is what it looks like on the plan. Okay, might be the most important thing to take away from plan corrections. What if I discover a plan error? On a plan that's mine or not mine? If it's not yours, phone or otherwise contact the land surveyor who authored the plan would be the number one thing to do. They will appreciate it. They'll want to make their plan proper, but that's, if you find an error, even if you're an articling student, don't be afraid to call that surveyor and just say, I think there's a problem on the plan. There might not be a problem on the plan. Maybe there is. They can take a look at it and say, oh no, this is how it should be for these reasons. But certainly do not be afraid to call up a surveyor and say, well, what about this? I'm not saying that everybody's nice or whatnot. I mean, people are people, but that is the proper and ethical thing to do. All right. That's going to conclude the land sales registration portion of this. I'm going to be moving into talking about a little bit of dormant plan issues. So what is a dormant plan? Well, any plan that's required to be registered in the land sales office that does not get registered within the required timeframes to register that plan in the land sales office. So basically, when monuments are placed, you need to register a plan is what it comes down to. The location of the requirement to register a plan has changed a little bit recently because we now have an essential resources document on top of the manual standard practice. For specifically, you can refer to Part F, Section 11 of the essential resources document for information on dormant plans. And then this excerpt that's on the screen is from Part B, Section 3.9 of the manual standard practice. So this is where it says, if you're going to register a plan, or if you're going to put monuments in the ground, you need to register a plan within 2 years of establishing the monument. Before registering and establishing a monuments plan for a right-of-way plan, you're going to make every effort to receive the client's consent to the registration. Under Section 81, subsection 2, that's where on a right-of-way plan, whoever ordered it needs to sign off on it. And it's talking about it includes not limited to educating the clients and sending letters of notification and following up the correspondence. Basically, hey, you need to sign this. The Pipelines Act says you need to have the plan surveyed and you don't. But in case this is something that was brought in more recent years, a process to actually register right-of-way plans. Maybe I'm getting ahead of myself here. Yeah, I'm getting ahead of myself. So the way it's worked is if you put monuments in the ground, even if it's for like a pipeline right away and it never got signed off on under Section 81.2, you still need to register a plan or register a monument plan. So you take that right-of-way plan, turn it into a monument plan, take that bold line off, put dash dot lines between all the monuments with the dimensions, just to show that you did put that, or that you put something in the ground and it's registered here. New Surveys Act has new timelines, actually. Previous to the 2022 Surveys Act, any reestablished monuments, you had 90 days to register a plan, which is kind of funny because now it takes more than 90 days for land sales to process a plan, so it's kind of impossible. But now we have reestablishment of Part 2 monument in the new Surveys Act, you got 1 year. Reestablishment of a Part 3's monument, you got 1 year to register a plan. Establishment of a new corner or a previously marked corner, 1 year. So a corner being something that defines a boundary. So what anybody else in the audience would say, if we're not going to register a plan, what might be a alternative? Like if there's monuments in the ground, we don't want to register a plan, draft a plan, what might we do that would take away that requirement? What action could you take? Well, I'm getting silence, so I'll say you can go pull the posts out of the ground. So if you have a bunch of posts, they're not needed, you don't want to register a monument plan, they're not in positions that are reestablished, or if they haven't been there for long enough for anybody to use them, pull them back out, and then you don't need to register the plan. You got to be very careful if it's a reestablishment, if it's been sitting there for a couple months. It starts to get worried that someone's accepted that corner, and perhaps I should register a plan on that anyway. Then we have the manual standard practice. So we have the Surveys Act, which is thou shalt, that you have to follow. We have the LSA manual standard practices, thou should, which is you should follow what's in here unless you have a really good reason to not. But Part B of the manual standard practice will say any statutory monument placed, whether it's a corner or not, 2 years. In terms of a pipeline right of way, I would say if there's a license for a pipeline, then you consider that a corner, even if it's not registered land sales, because there is a license from the ERCB that is based upon that survey, based upon that monument. That's a monument. So that would be, you have 1 year to register a plan. If not, if it's just not licensed, no one built the pipeline, then 2 years is what you got. Sorry, I was getting ahead of myself in the dormant plans for the right-of-ways, but one thing to note, the Pipeline Act, important piece of legislation for us. Section 4 says right-of-way boundaries must be surveyed according to the Surveys Act prior to a license being granted. This is specific to oil and gas projects, so if you have a water pipeline for a municipality, this doesn't apply because it's pipelines just for oil and gas. It'd be different legislation for a water pipeline. So, and this affidavit down here is for situations where you've been unable to get a company to sign off on that right-of-way plan. So oil and gas company no longer exists, been transferred 14 times, and now nobody knows what's going on with that particular line. You've tried everything to try and get them to sign. You don't really want to convert it to a monument plan because that's, it is right-of-way. There's a license based upon it. You want it properly registered. So you say, we've really tried hard. We weren't able to do anything. It's benefit to public safety. I hereby consent the plan prepared by me or another authorized ALS in the respect to the following lands to be registered land titles. So until about, correct me if I'm wrong, maybe 6 years ago or so, the ALSA was working on this. Before that, we didn't have this option. Either you'd have to register a monument plan that took time and energy to convert to a monument plan. Perhaps some surveyors may have said, authorize or plan ordered by Bruce Goodham. Yeah, Bruce Goodham ordered this plan. Not really the right way to go, but technically that may have happened. But generally turned to a monument plan. And you can look up sections SUR-6 of the Land Sales Procedure Manual for information on this. If there's no questions on dormant plans, our last section is going to be on the corner recordation index. So this is something I think is pretty cool. I use it quite a bit. So there's a requirement that if you reestablish a monument, you need to register that you reestablished it. But do we have to do that land titles? Well, that used to be the only option, but that's kind of annoying if I'm doing a real property report and maybe I find a wood post. Like, oh, well, I'd really love to slam an iron post into that corner and preserve the location. But now I have to draft a monument plan, register the land titles, pay them $100 to map it, even though there's nothing to map. That's pretty annoying. So maybe can we have an alternative to that? And the alternative is the corner recordation index. This is managed by the Alberta Land Surveyors Association. And in cases where a monument is restored, not reestablished, but restored, then we could file it in the corner recordation index. So that would be if you found pits, but not an iron post, and you restored the location of an iron post based upon physical evidence on site, it can go in the corner recordation index. If you found an iron post that was all bent up, yeah, I see you there, John. Then you can put that in the corner recordation index. John, did you have a question? I just saw you raise your hand, so maybe not. Oh, you're on mute if you are talking. That's okay. I'll move on here. So, yeah, in case where it's restored, reestablishment, if you use math to put it back in, not going to fly here. That's got to be registered land titles. So here's a monument screen, or add a monument screen. You put your file number, your registration number, the date it was restored, where it is, approximate latitude, longitude, what you found, what you restored. There's also I'll show on an upcoming slide, a sheet you can fill in with a little drawing. And if you have ABBA data, which would be most oil and gas surveyors, you can also search and look for corner recordation index registrations in ABBA data. So that's pretty cool. You can also, if you have Trimble Business Center, you can even create a KMZ file. So you open up Google Earth and you can search for corner recordation index entries that way. So if you're working in a particular project area, that's an option, or you can just go into the LSA site for a corner recordation index and search by radius or by legal description to see if there's any entries in the area you're working. Or maybe you're out in the field and you find a post, it has a permit number on it, but you're like, oh, where did this come from? You might just have to look at the corner recordation index and say, oh, Gary found some wood and he put a iron post in that corner. Well, that's pretty reliable. I'm going to use that. So as I said, only for restoration, not for reestablishments. This is what the login screen looks like. If you don't have a login and you're a registered surveyor, give Dawn, or I guess not, she's not there right now, but give the ALSA a ring and say, hey, I want login and password to the site so I can search for and enter corner recordation index entries, and they'll get that for you. So I mentioned you can search by Alberta Township System, plan, block, lot, date, coordinate, and radius, ALS number if you're looking for restorations by particular ALS. There's also, you can look up records based upon the fact it was a restoration or a double posting, removed monument. And this is getting a lot of uptick. So I did a little research. January 2021, there was 545 entries. That's pretty decent. But by January 2023, 2,763 entries. So it's like do a quick math, like a 500% increase in entries into the corner recordation index. So if you're a surveyor that's saying, well, I'm not even going to bother looking at that when I set up jobs because no one's really using it. Well, you know what? 2,700 is quite a few entries. There are people using this. So as we populate it, it'll become more and more of a resource for file research and what you should look up before you even go to a site, as opposed to just looking it up when you find someone's post and say, well, what the heck is this and where did this come from? So here's an example of a manually filled in form that I scanned in just to a PDF. I did it this way because I could just copy clip a piece of my RPR and say, oh, I found a bent post that I broke and it wasn't really worth putting back in, so I just put it in a new monument. It's also a great example of why you pull out a whole post when you find it's bent, and you don't just hit it back straight in the hole because it might be a lot deeper. So this is an example where someone had found the top of the post, maybe in the wintertime. They're like, oh, well, I'm just going to hit that back straight and tie it in and use it for my survey. Well, the actual corner is down here, a foot away. Should have pulled out that full monument and straightened it properly. Shame on you. But so in this case, we pulled it out, tried to straighten it, it broke. So we put a new iron post in the original eye hole, more over here. Filled in approximate latitude, longitude. Said we placed P254, my permit number in the hole. Date, file number. And you'll be able to get this information. You can actually even attach, like this picture is attached to the entry in the corner recordation index. So if Ross is looking this up, he gets not only this restoration of a survey monument PDF, but on page 2 of the PDF, he gets this picture of what happened. So 100 years from now, when someone's looking this up saying, well, you know, why is it that this surveyor says the post was a foot away from where this surveyor says? They can look this up and say, oh, well, that makes sense. That's why it's a foot away. Okay, and that's actually the end of my presentation and the end of the section on corner recordation index. That's been 1 hour, so my timing is pretty good, I think. Thanks everyone for paying attention, and would love any questions or clarifications on the land titles process. We have a guru of land titles here in Tony Bennett, and thank you for being here.
Actually, no problem. There were a couple of things I thought I would sort of highlight. Preparation of court orders is very, very tricky. And it's important when you're dealing with them to be sure that you're dealing with all parcels. You've got 2 sides to every line, and make sure that you're referencing that you're changing more than one boundary. So you want to be very complete. The other thing would be judges' orders directing you to do something like adverse possession. And I'm hoping that'll disappear soon, but until it does, when you're adversely affecting a parcel, your court order has to address the land being changed, what's left, so that you have to be very thorough in your land descriptions. It's one of those things. When you get on the ground, you can lose sight of where you're going. So you need to be careful. And the only other thing I would say is the oldest plan I registered was one done in the 1930s. It was a road plan that was carefully filed in Crow's Nest Municipality's office someplace. And they sent it in about 1998 or 9.
Okay.
So what we had to do was we had to check the Surveyors Commission, and we had to go back through the town records to find out whether the signing authority was actually the signing authority at the time. Turned out to be the case, so we were able to proceed registering it. And that was a last linen I saw.
Oh, wow.
But in any event, excellent. I thought you did very well.
Now that is a dormant plan. Absolutely.
Yep. Thanks much, Michael.
Oh, thank you, Tony. Yeah, I guess that's why we love this profession, is because nothing's ever straightforward and it's interesting.
Do we have any more questions for Michael?
I just wanted to say thanks, Michael, for putting together so much of an excellent presentation, especially details, and I had specifically asked you about this on the CRI and such, when many of us, even as professional land surveyors, we may not do it but once a year, once every 2 years, once every 5 years. And I think something like this is very useful to go forward with some solid information that people can refer to. So this will be both in the drive, and it'll be going up on our YouTube page as well.
Excellent.
Thanks.
Any other questions for Michael? Great presentation, Michael. While we're waiting for maybe some more questions to pop up, next week's presentation is visualizing construction progress, and our presenter for next week is Ryan Walker. So visualizing construction progress with Ryan Walker. So stay tuned next week for his presentation on January the 25th. Do we have any more questions for Michael? Great presentation. I would like to thank you, Michael, for your presentation today, and it'll be online shortly once Brian edits it. So thanks again, and look forward to maybe another volunteer session with yourself on another topic. So thanks, Michael, for your presentation. And I'd like to thank everybody that tuned in for Wolgar Geomatics College, and stay tuned next week for visualizing construction progress. So see you all next week, and good night. Is this Wolgar here? Is this? Oh. Anyways, good night from Wolgar Geomatics College.
Excellent. Thanks so much, Ross. Take care, everybody. Thanks, Michael.
Yeah.
Everyone, thank you.